Sir, can I have your full name and date of birth?
Christopher Elijah Mackay Fantastic, March 28, 2005.
Thank you. And then, officer, did we get down an officer? I think the counsel wants to appear. I just need somebody over there. I think she wants to appear in this case. Okay, thanks. All right, and then the appearance of counsel, please.
Thank you, Your Honor. Brooke Gahn on behalf of the state.
All right, Mr. Fantastic, here in a new case. The allegations are aggravated robbery, a Class 3 felony, and assault, a Class 1 misdemeanor. The alleged offense date is August 18th of 2023. I am appointing a lawyer to represent you, and your next court date is going to be a status conference Wednesday, January 17th at 8:30 in the morning in the downtown Superior Court, with a preliminary hearing January 19th at 8:30 in the same court. Before the court sets conditions of bail or release, what did the state want to say?
Thank you, Your Honor. The state's requesting a $100,000 secured appearance bond in this matter, and we'd also ask for electronic monitoring if Mr. Fantastic is able to post that bond. First and foremost, the state's extremely concerned for the safety of the community as the result of Mr. Fantastic's alleged dangerous actions. Not only was this a vicious attack that caused injuries to a minor, but it was a planned and concerted plot against the minor victim to get back at him for reporting threats to his school. The victim could have been much more seriously injured than he was. He's lucky not to have suffered permanent physical injuries as a result of the suspect's actions. However, the victim will likely suffer permanent emotional and psychological damage as a result of these events. There are a number of aggravators in this case that we believe justifies that large of a bond, including the fact that this was a planned violent attack amongst a sizable group of people, including the defendant, on a minor victim. Additionally, not only were there accomplices in the attack, but the victim's property was taken. The victim had little way to defend himself during the attack as he was prone on the ground, and the defendant's a clear danger to the community. The attack was all shown on video, and there was a lengthy investigation done by the Gilbert Police Department as a result of the defendant's actions. The state also wants to reiterate the fact that this attack is only one among several in the community in Gilbert that have been perpetrated by a group that the defendant belongs to, with several other violent juveniles and adults. The state's concerned about the constant victimization of the community and potential future attacks if he is not given a high bond. Additionally, that bond will hopefully ensure that the suspect is held responsible for his violent and dangerous actions, and also protect the community against further attacks.
Counsel, what, if any, evidence is the state proffering to the court that would show this person is in the group of violent young people that you are describing?
Your Honor, this attack...
All I have is literally your statement, plus obviously what's alleged against him.
Your Honor, the Form 4 indicates this was an attack on a minor victim outside of an In-N-Out burger in a parking lot.
No, I understand that. I guess what I'm saying is it sounded like you were trying to link him into, I know there's been some recent publicity about, roving attacks in Gilbert. You just linked him to it, but I'm saying, do you have anything to support that? Other than just what the police may have told you?
That's the information that I have from the Gilbert Police Department.
Okay, and I guess I have to say, I can't, without knowing why the police believe that he is a part of that sort of gang of kids, not an organized gang, but group, I guess I can't give that really any weight. The bare allegation of his participation in that is, without the police, providing some support for why they think that, the court is very reluctant to give that much weight, particularly when the offense is now 6 months old, or 5. Anyway, I'm sorry, were you done?
Yes.
Okay. All right, Mr. Fantastic, I've considered what's been alleged against you in this booking paperwork. I did consider the statements of the state, although I did note to the state that the court might have considered this allegation that you may be involved in other similar acts, but without any supporting information regarding what the evidence is that you were involved in those attacks, the court is, not considering that. I'm setting bail based on what the police have alleged against you for this incident. It does appear to be a strong weight of the evidence. It does appear to greatly increase the risk that you pose to this alleged victim, and to the community, because if you did these things, then you are a danger to the community. But the court also believes, and certainly when it's now a 5-month-old allegation, without interim information regarding what, if any, behavior may have occurred in between then and now, this court finds that supports a bail in the amount of $25,000 secured. That means you can use a bail bondsman. You will be on an ankle monitor if you post that. This court is very concerned about the possibility of victim or witness intimidation, and that's one of the purposes of bail, is to protect against that. If you post the bail, you go on an ankle monitor. You comply with the electronic monitoring program. You will not have any contact with the alleged victim or his family or his property. Not through social media, not directly or indirectly. That is literally in your paperwork. And you're very young, Mr. Fantastic, and you've been through the juvenile system a little bit. This is not the juvenile system. If you have any contact with the alleged victim, you could be booked for aggravated harassment. If that happens, you will be held without bail when you have this hearing on an aggravated harassment charge. Talk to your lawyer about that. Look up the statute. I put it in your paperwork. The court takes your case very seriously on these facts alone. Sounds like the police are looking at you for other things, so it would be very much against your best interest to do anything that could cause you to be accused of violating release conditions, particularly no victim contact orders. Do you understand what I'm saying, Mr. Fantastic? All right.
And, Your Honor, I had one other request. The state would ask to seal the Form 4. It contains minor co-defendant information, I believe, as well as the minor victim information.
Okay. And, so I'm going to grant that. I need to re-sign this. So what that means, Mr. Fantastic, is the state needs to redact the identifying information for juveniles out of your paperwork before it goes into the public record. You will have access to police reports and the charging document and everything through your lawyer. But before the booking paperwork gets uploaded into the public system, the state has to redact that juvenile information. So that is granted, and we'll seal that Form 4. All right, everything I've just told you will be on your paperwork, and if you give us a chance, I don't even know if we have to reprint it. I don't think we do. Just have to reclose it. Okay, we'll send it out to you. Thank you.